wanted to talk to you today about the deposition that's going to be coming up in your case so that you kind of understand a little bit about what you can do to prepare yourself. Depositions are normal. They are a really, really normal part of this workers' comp process. And they happen in most of the cases where we come on board. So don't feel like your case has been red flagged or there's something strange going on. It's just a normal part of the process. And so the number one rule for you to keep in mind in this deposition is that you are not here to tell your story. And I know that's really hard because, for most people, they find that if they can just explain themselves to somebody, if they can just explain how much pain that they're in, or if they can just explain how they're feeling because of the situation, that person will just understand. And that's really not the point of the deposition. Your goal in this deposition is not really to convince that attorney that you're hurt, not to convince the attorney how it happened. It's not to convince anybody of anything. Your goal really is just to try to answer the questions in today's deposition. So what I'm going to tell you is keep your answers short. Keep your answers very simple. As much as you can keep your answers to yes or to no, those are actually the best answers that you can give. I promise you that if that attorney wants more information from you, that attorney will ask you a follow-up question. That's the attorney's job. And so if they want to know, hey, why is your answer yes to that? They're going to ask you, hey, why is your answer yes to that? That attorney will ask that follow-up. I don't want you to feel like you need to do that follow-up because you really don't. It's, yes is a sufficient answer most of the time. So the example I always give clients when we're doing this deposition prep is, in terms of how I want you to answer the questions, is when I get really upset and mad, I don't get angry and throw things and yell at people or anything like that. I just don't talk to anybody. So at the end of the day, when if I'm upset with my husband, he comes home and he says, hey Amanda, what do you want for dinner? If I'm mad at him, my answer is one or two words: tacos. And if it's his job to say, okay, well, what kind of tacos do you want? I'm not volunteering anything. So just one word answer. Amanda, how was your day? Fine. Amanda, what do you want for dinner? Tacos. And then he needs to ask that follow-up question because I'm mad and I'm not talking to him. So that's kind of how I want you to be in this deposition today. I want you to be really short, sweet, and to the point with your answers. Yes, no are the best answers that you can give. Now there's going to be some questions that get asked of you that you can't answer yes or no to, and I want you to be really short with your answers. 10-15 seconds is probably enough, and wait for that attorney to ask you further questions. If you notice that you're talking for a little bit of time, it's just nervous energy. As much as I tell you, don't be nervous, this is totally fine, this is totally normal, you're still going to be a little bit nervous because that is so common. And sometimes what happens is you just kind of start getting really chatty. And so if you notice that you're doing that and you're like, oh, I've been talking for a little bit now, just stop. Even if you're in the middle of a sentence, just stop and wait for the attorney to ask you another question. This is your deposition, so you get to take a break whenever you want to take a break. You just say your magic words of, I need a break, and we take a break. It's that simple, really. You can take a break for any reason or for no reason. So you can take a break because you want to go get a water, or you need to go to the restroom, or maybe the attorney is just getting on your nerves and you need to walk away for a minute. Any of those things are totally fine. You just say, I need to take a break, and then we'll go off of the record. The attorney is probably going to be asking you different things about your injury or in your past that you may not remember with exact detail, and that is totally fine. For example, in your deposition, I guarantee you that you're going to be asked about different dates that things have happened to you. Dates that you went to the doctor, dates that you were injured, dates that you reported things, things of that nature. You're not going to remember those dates, and that is fine. Nobody really expects you to remember exact dates. They will ask you, however, your date of birth. You probably should know that exact date. But after that, nobody really expects you to have exact dates memorized. It's totally fine for you to give an estimate or an approximation. So, for example, if they're asking you when you went to a doctor and you don't remember exactly, you can say, well, my best estimate is, it was April 1st of 2019. Or you can say it was approximately, it was about, around. Any of those things are totally fine reasons for you to say, your best estimate. What we don't want you to do is we don't want you to guess. So we don't want you to go, April 1st of 2019. Because what happens is the court reporter is going to write down exactly what you said. So then the question is, when did this answer, or when did this, you seek medical treatment? Answer, April 1st of 2019. And that's not really exactly what happened, because the court reporter can't write down the tone and the body language and things like that. So that's why we don't want you to give any guesses, but estimates are totally fine. So just remember to use those extra context clues to give us the hint later on that you're giving us your best estimate. You have to answer everything verbally. You're watching me in this, and so you can kind of see what I'm doing. So if I nod my head yes, you can see that I'm nodding my head yes, but the court reporter can't write any of that kind of thing down. So you have to answer everything verbally. So if they ask you a question and the answer is yes, you actually have to say yes. You can't nod. So you can't gesture. So if you're talking about an injury of some sort and you say, oh yes, it hurts right here. Well, you're watching me. I just pointed to my lower back. But the court reporter will only write down, yes, it hurts right here. And later on, it's just kind of confusing as to what it is that you're talking about. So make sure that you explain exactly what it is that you're pointing to. Imagine if you were on the phone and you were trying to talk somebody through what you were saying. That's kind of the same thing, even though you're still seeing that person in the deposition. It still has to be written down as though that person can't see you later on. So those are kind of the big takeaways in terms of how I want you to answer questions when it comes to your deposition time. Now, as we get closer to your deposition, before the deposition, usually just 45 minutes to an hour before the deposition, we will give you a call, and or if we're meeting in person for the deposition, we will kind of walk you through everything that you need to know that's more specific to your particular case, the facts and things like that, and the types of questions that they're going to be asking you. But these are the real big takeaways that I want you to really be thinking about now. If you don't remember anything else that we talked about or anything else that was said in this video, I want you to remember, do not talk a lot. Keep your answers short, sweet, and to the point. That is really the biggest rule, but it's really hard to do because we have to fight that urge to tell our story. But remember, this isn't the time for that in the deposition. So I think that was all I wanted to cover, but you will receive more information from the office in terms of the follow-up, where we're going to talk more specifically about your case. Thanks so much.